is the Electile Dysfunction Podcast with Ashton Cohen.
All right, guys, welcome back to the Electile Dysfunction with Ashton Cohen. I am Ashton Cohen. I'm joined today by Michael Warren. He is a judge, a constitutional scholar. He co-founded a group called Patriot Week, which is dedicated to teaching the Constitution and constitutional principles. His latest book is America's Survival Guide. Goes over some of the topics that we're going to get into here as well. Michael, thanks so much for being with us.
It's my pleasure. Thank you.
Appreciate it. I wanted to start off with sort of taking a macro view of the Constitution, then we could get more micro. You're obviously someone who would describe themselves as an originalist, someone who is thinks deeply about the Constitution and constitutional issues and our framers and the original intention behind it. What do you see today as sort of the biggest issues, maybe potentially undermining the Constitution? What concerns you most as an originalist with respect to our Constitution and the attacks on it, and any sort of issues that you see that are sort of undermining it?
Okay, so I guess I'd answer that in two ways. The first is that just general ignorance and complacency about, I guess I'm going to answer it in three ways. General ignorance and complacency about just the Constitution in general. I just had a fabulous session with a bunch of eighth graders at a local middle school going through the Constitution, and it became painfully obvious that the students, despite the best efforts of their teachers, really don't know much about the Constitution and how it's organized. And as a former member of the State Board of Education in Michigan, it is I've been following this for many years, and I'm really just disheartened by the lack of civics and history education in our K through 12 schools, as well as our universities. The first chapter of my book, which is America's Survival Guide, How to Stop America's Impending Suicide by Reclaiming Our Founding First Principles in History. I know that's a long title, but America's Survival Guide you can find on Amazon or any other online retailer. I go through a series of studies about the general ignorance of our population. And for example, when I wrote the book, the studies revealed that just barely half of the people understood there were three branches of government. It's not that hard. There's only three. There's the legislative, executive, and judicial branches, Congress, president, and the Supreme Court, or the judiciary. And that's, how are we supposed to survive as a free people if barely half of the people even understand that basic concept? Well, more recent studies have shown that less than half of the people understand that. So we're going in the wrong direction. And this has been an endemic problem for a good generation, if not longer. So putting aside jurisprudence for a second and the Supreme Court and judiciary, just the fact that our general public does not understand the Constitution and our history is very threatening to our survival as a free people. That's what the book is about. So if your viewers are interested in that, again, it's America's Survival Guide. The second thing is that there's more recently, it's always been a theme and a thread of our history, where the people that have attacked our founding first principles. Those principles come out of the Declaration of Independence, the rule of law, unalienable rights, limited government, the social compact, equality, and the right to alter or abolish an oppressive government. And there have been people like Marxists and fascists and others who have challenged those principles, but they've always been a very, very small, tiny minority of people. A large segment of the population believes in the Constitution, the Declaration of Independence. Maybe they don't understand it, but at least they accept those principles. And now there's the critical race theorist, a CRT. There's a number of others that are going at the heart of our founding. Not only just saying that our founders were racist, and some were undoubtedly, but that our whole system is irredeemable, cannot be reformed, in the 1619 Project, others like that. So we've got those two streams that are assaulting our Constitution. And then the third thing would be what you started with, which is originalism versus some other jurisprudence. So I do believe that I believe in the separation of powers. So the separation of powers holds that the legislature should make the law, that the executive should enforce it, and the judiciary should interpret the law when there's a conflict and resolve disputes. And if there is a law that's in conflict, or executive order or something else that's in conflict with the Constitution, the court has the duty and responsibility to strike down the law. The judiciary is not a set of enlightened princes, self-anointed governors, or a board of revision or a super legislature that should fundamentally change the Constitution. That's the role of the people. The Constitution is the people's document. It was ratified in 1788. It's been amended 27 times. There is a process for changing the verbiage of the Constitution and how it works, and that's the amendment process, or you could even call for a constitutional convention. There are, and the way that you adhere to that separation of powers and the role of the judiciary, in my view, is that you interpret the words as they were understood at the time that they were adopted and ratified. And you can discern that by speeches and documents that were used to, it doesn't have to be just by the proponents, it could be by the opponents as well. But what did people really think this document was doing in light of the historical circumstances? If there's a specific word that has kind of a term of art, what did that term of art, what did due process mean, for example? What did freedom of speech or free exercise of religion, what do those words mean? And then the judge should extrapolate from that to current day circumstances. Because, I'm not saying that just because there weren't wiretaps back in 1788 or 1791, that we shouldn't, we should just ignore the Constitution in connection with wiretaps or cell phones. But you should say, okay, what are the underlying principles? What are we trying to protect here? And then apply them to current day circumstances. So that would be my view of originalism or original intent. There's several variations of that theme. I don't know that it's worth getting into it, but my particular version is that what was the common understanding of the people that ratified the document? Because those are the people that made it come into effect. So you'd look at not just, for example, James Madison, who's the father of the Constitution, and what he thought, or James Wilson, or others that were important to the Constitutional Convention, but you look at the debates in the ratifying conventions of Virginia and Massachusetts and Pennsylvania. What did they think? When you're talking about amendments that were approved, what did those that wrote the 11th Amendment, what did they think they were doing, the First Amendment, and see the ratification process in the various states.
So there are a couple things I wanted to touch on that you mentioned I think are important. First off is, so when talking about originalist intent, I like the example used about the wiretap issue, right? So obviously our framers couldn't have perceived or foreseen GPS technology, right? And so the Supreme Court famously said that you can't put GPS device on someone's car without a warrant, right? That's a search and seizure that falls in the Fourth Amendment. And it's interesting because people will always people on the left will make an argument about, particularly in respect to the Second Amendment, about well, that was only applying to muskets. They couldn't have foreseen AR-15s or something like that. It's like, well, they couldn't have foreseen GPS trackers either, right? And because we can go back and we can look at the principles which underlie these amendments, we're able to say, okay, well, would this be a unreasonable search and seizure to just be able to track someone's movements without probable cause, without warrant? And the Supreme Court, I think it's pretty clear, even if you're not a constitutional scholar, that seems like an invasion of privacy that requires a step such as getting a warrant in order to do.
Also a trespass.
Right, exactly.
Who has the right to screw around with your car? I never did understand the reasoning behind those decisions, but there was, as you pointed out, there were a number of circuit courts. So that's the Court of Appeals on the federal level, which found those to be perfectly constitutional, that operation. Thankfully, the Supreme Court came in and reverse those decisions.
Right, absolutely. And with respect to your view on what judges should be, what the role entails, there are people. So one of the sort of main dividing lines politically is, and to make a generalization, although this is pretty spot on, right? So people on the right generally want judges to have a originalist interpretation, stick to the Constitution, what it intended. People on the left generally want judges to be almost like super legislators, right? Putting their own opinions as to what the law should be. Why is that? Why is that bad? Why is that dangerous to have judges act like legislators and insert their own opinions of how the law ought to be, not what the Constitution says?
Well, I think there's a couple of reasons. First is that that's not the role of the judiciary. And so, to flesh this out, you have this one perspective that views the role of the judiciary to continue with the evolution or the spirit of the Constitution, and that they're supposed to, in one sense, nudge along constitutional theories to come to outcomes which they think are just. And so they believe that, because it's a constitution, it's narrowly drafted, and because there were some injustices at the beginning of the founding, that they should be able to use the Constitution in a way that results in an outcome that they appreciate and think is best for the country. And but that is not the role of the judiciary. It doesn't say, and the Constitution is very quick on the Supreme Court. It just says the judicial power is vested in the Supreme Court. Well, the judicial power does not mean the legislative power. And when you give, especially in the federal system, these people, it's the best job in the world ever. They're appointed for life. They're unaccountable to voters. They can't be fired unless they're impeached, and it's extremely difficult to do that. Their salaries can't be reduced while they're in office. They're very insulated, which was the point of all those things, insulated from political passions of the day. But the downside has been, there's been an arrogance, some people call it black robe disease, where they believe, well, I'm smarter than the Congress. I'm smarter than the local judiciary or local legislatures and local judiciaries. I'm elected, for example, so there's some accountability between my decisions and the people. I also have a judicial tenure commission, which is if I go off the rails and I'm corrupt, they can boot me out of office. The Supreme Court doesn't have any of those checks other than impeachment. So I think there's this temptation, and it's exemplified in Judge Bork's book, The Tempting of America, where there's people that are good-hearted, they want to do good, they see they have the power to do good, if only they can get 5 votes on the Supreme Court to do the good, and then they convince themselves in a number of ways that the ends justify the means. But the problem is that subverts the little d democratic process and little r republic, because the lawmaking is supposed to be vested with the Congress. And then, of course, the president can sign or veto legislation. And so those branches are accountable to the people. So if they make decisions that are unwise or unpopular, they can get swept out of office and replaced. That is not the case with the appointed for life judiciary. So when they make decisions, and I'm not going to take a position on the decision, but Roe versus Wade was very controversial. And we're still fighting over Roe v. Wade. I mean, I think we're going to talk about this a little bit later. When you have these extremely controversial positions that are staked out by the Supreme Court, the only way to undo that is either amend the Constitution, which is extremely hard, or reverse the decision. And then if they reverse the decision, then it looks like they're playing politics, even though they may have been playing politics the first time around. But then if they reverse it, then it looks even worse. And so there's all these institutional barriers from reversing a decision that should never have been made. And again, I'm not saying that's Roe, but just some people make that argument. So there are, by allowing the judiciary to become that super legislature or making decisions outside of the public accountability, it undermines the social compact. The idea of the social compact is we create a government to protect our rights. We have to consent to the government, and the government has certain duties for us that they have to fulfill, like protecting us and protecting the borders and all that kind of stuff. And when you have a judiciary that comes in and usurps their role, they're pulling out the consent lever, the very, very key important element of the social compact, because there's no consent to the judiciary making that decision if they're going outside of the bounds of the Constitution. And that's why it's so corrosive and corrupting to allow what some people would call judicial activism, but decision-making that's ungrounded from the true meaning and historical understanding of the Constitution. And just to give it a little bit better fleshing out, I want you to think that you're, let me pull this out here. So we've got, I don't know if you can see it. So let's say that's the football field, right? And we have a controversy, and there's not always a super clear answer, even with the history and the reviewing of the various documents or whatever. So you have this controversy and it's at the 50-yard line, and you might say, okay, it can come over here, over here. There's play in here. Some founders thought this, some founders thought that. The meaning, public meaning might have been over here, but there's a counter definition over here. So, but you're playing within the 40 to 40-yard line. The problem with the spirit of the Constitution and the unanchored decision-making is all of a sudden you get a decision over here. And you're like, that has nothing to do with this. It was unfathomable that this decision would ever happen because it's nowhere near the 40-yard lines.
Right.
It's way over here. It's on the 10. It's in the end zone. It's off the field. And so that's where we have these eruptions that usually devolve into big, huge political debates, is when you have a decision that's not in the 40-yard line, it's over here. And then that undermines the legitimacy of the court. It undermines the legitimacy of the Constitution. It undermines the legitimacy of the social compact, the rule of law, because we're supposed to follow the law, not personal predilections. And it just looks like the court is playing games. And every generation or so, we have at least one of these decisions that go boop, over here, and everybody throws up their arms and what is going on, and there's cause to impeach and all this. So that is not principled decision making, that's policy making when you're out of here. So like the wiretap example, you might have a fight in here and you could say, yeah, it's constitutional, yeah, it's not, but you're fighting within this range. It would be like saying, and now everybody's entitled to a free cell phone from the federal government. That would be over, right. It has no correlation to what's going on in the field.
So speaking of stepping away from basically the intention of the Constitution and what the framers intended, there's a recent news story that's been making the rounds about, say, the Joint Chiefs of Staff, Mark Miley, who apparently, according to a new book by Woodward, was speaking to his Chinese counterpart, basically the equivalent of, I guess, the Chinese Secretary of Defense. He's a Joint Chiefs of Staff, but he was speaking to the head military person in China, basically telling him, according to this book, that, well, if America decides to attack, I'm going to warn you first. And then he also told his subordinates that to report to him directly, not the President of the United States. So this is a important story on two fronts. Obviously, it's a complete subversion of the Constitution and what the powers are. The Joint Chiefs of Staff doesn't even have authority to make military decisions. He's supposed to be an advisor to the president, who is constitutionally the commander in chief. But more so, it seems to be the latest example of what some would term this notion of the deep state, which used to sort of, in my ears, be a conspiratorial kind of thing. But when it's applied to meaning this administrative state with unelected bureaucrats who have significant control over people's lives, all these administrative agencies who are unaccountable to the people, administer insane amounts of control over people's day-to-day lives, more so than Congress does, and them sort of subverting the will of the people through their democratically elected representatives. Is this not problematic? Or I know you're obviously bound by judicial ethics, being a current judicial officer or judge. But is this, how do we make sense of this in terms of what the framers envisioned? It's a fourth branch of government that's getting bigger and bigger and bigger, becoming more powerful, being entrusted with more and more authority over people's lives. How do we reconcile that with sort of the framers' intentions, and if it's sort of out of the scope of what our Constitution is supposed to be about, with the separation of powers and three branches of government, what can be done to sort of rein that back?
Well, thank you for the question. It's very important, and I'll try my best to do a little bit of illumination while staying within the rule of ethics. I would just want to point out to your viewers and listeners that some of this is addressed at patriotweek.org, which is the organization that I co-founded with my then 10-year-old daughter. And some of it's in America's Survival Guide. But getting to your question specifically, it's interesting because the linkage you've made between the administrative state and this newest controversy is not one that I would normally have thought of on my own. You're the first person I've heard that from. And the reason I say that is because he's in the military, and most people wouldn't think of the military being an administrative state entity or creature. The Constitution makes this very clear that the president is the commander-in-chief of the military. It also makes very clear that Congress is the entity that is vested with the authority to declare war. And of course, we now have a situation where much of the war-making authority is vested in the president through congressional acts. And normally when there's a major commitment of troops, I mean, we haven't had a declaration of war since World War II. Mm-hmm. So 1941, it's now 2021, and we've had Korea, Vietnam, the Gulf War, Afghanistan, Iraq. Yep. I'm sorry.
Yeah, Iraq. Right.
Iraq. So we've, let's put aside the more what people might consider minor, like Libya.
Yeah. Right.
And Panama, and other issues that we've had, military strikes against ISIS. We've had these five, unequivocally major wars where there's not been a declaration of war. Now, Congress has instead used these other mechanisms to fund all those wars because the president doesn't have the ability to spend money that's not appropriate unless it's appropriated. And they have done authorization to use of forces resolutions, which have said, yeah, go into Iraq or go into Afghanistan, but it's not the constitutional mechanism that was envisioned by the founders. And clearly the founders strongly believed in civilian control of the military. They would not have vested the president with that authority. And in fact, George Washington, who was our first president, of course, our second president, literally got on horseback during the Whiskey Rebellion and was going to lead, troops. And James Madison also led troops. He was no George Washington, brilliant constitutional architect, but he was no military man. But he literally got on horseback during the War of 1812 when the British invaded Washington, D.C. So, we have not had Trump or Obama or Biden go off and lead troops. Probably that's okay with the American people, but if you think about it, they could. And so, so you've got that issue about commander in chief, and did what the Joint Chiefs of Staff do conform with or undermine the president? Then we have this other issue of this huge administrative state. And I think it is fair, I don't think there's any controversy over this, that the founding fathers did not envision a huge administrative state. They clearly believed that there'd be a small administrative state. For example, various cabinet members had a variety of different administrative roles, even early on out of the box when Washington put together a cabinet. That is a tradition. That's not part of the Constitution. The legislature, the Congress passed various laws to deal with trade and commerce and the military and the Navy. And they literally actually debated these laws. They knew what were in them before they voted for them. They funded these things directly. There was a chain of command that went straight up to the president. He was in charge of all the bureaucrats. That was the state, the administrative state that they envisioned. And now we have, you go to Washington, D.C., it's a beautiful place. Why is it a beautiful place? Because they take taxpayer money, they spin it around in DC, build office buildings, put bureaucrats there. And I don't mean that in a bad way. I mean, that's just their job. They're bureaucrats, and they're these huge departments. They have huge office buildings. And the president does not have direct control over hardly any of these people. I think the last time I looked, there were about 4,000 positions that the president had direct appointing responsibility over. And then everybody after that is somebody underneath somebody he's appointed, right? So there's theoretically a chain of command. You appoint the defense secretary, who appoints, the undersecretary of the army or whatever. I'm not sure the bureaucracy, but eventually you get the people that are all appointed underneath them. And then the president's in charge of the top dog. So maybe somehow he's in charge of the guy that's 30th down in the list. The challenge with that is it really does weaken this idea of the social compact, where the people that are in the government are accountable to the people writ large based on their electing the president and the Congress. And when you have these different levels of insulation between the people at the top and the people at the bottom, then you have, it's very hard to hold people accountable for decisions. And every administration has people that seem to go off the rails, they get criticized, they're yanked in before Congress, there's a hearing. Very few of those people lose their jobs.
Right.
Very few of them, maybe they don't even apologize, or, and then there's a rulemaking process, which was not really envisioned by the founders. It's really quite remarkable how big the federal government has gotten, still using the old Constitution, which really had very little foresight in connection with how that would happen. So back in the 30s, the United States Supreme Court was striking down various delegations of authority by Congress. So that's what they do. Congress passes a law and it says, there shall be the FDA, the Federal Drug Administration. We're going to create it. This person's going to be appointed by the president. We're going to give it X number of dollars. Its job is like this big mission statement. And then the FDA goes on its way, and then it has rulemaking authority. So there's a process to make the rules. And the US Supreme Court said, nope, that's unconstitutional. It's not provided for in the Constitution, the way that you're delegating this authority. And then the Supreme Court changed its decision-making and said, well, as long as Congress is passing a law that allows the administrator to have some articulable criteria by which they're passing and performing their duties, then that delegation's okay. So you can't say, Congress can't say, Mr. President, we give you all authority to pass the law.
Right.
That would be an unconstitutional delegation of authority. But it can say, Mr. President, we're going to delegate to your administrative agency regulation of food and drugs and for health and safety reasons, and we'll give you some broad criteria. And as long as you're fulfilling that within the broad criteria, you're constitutional. So that's the state of law now. There is some serious concern that's been expressed by Justice Gorsuch and others on the Supreme Court about the viability of that, whether or not that should continue to be the law. And that will be fascinating to see the developments. There's been actually a lot of litigation about administrative authority recently. A number of the Trump initiatives were struck down because they weren't done in compliance with the Administrative Procedures Act, which is how you're supposed to pass a rule. And then there's now Biden's attempt to undo things that Trump put into place is also being gummed up by the same. So it's a bipartisan issue. And it'll be really fascinating to see if the Supreme Court if they go as far as has been suggested by Gorsuch, and that perhaps we need, that they would rethink this whole idea of the delegation doctrine. In Michigan, Governor Whitmer passed an executive order locking down the state because of COVID, and the Michigan Supreme Court struck that down because she did it under an emergency act that was passed in 1945. This was not an emergency act for COVID that had been passed by the legislature. It was an old act, and it basically said, in times of emergency, the governor can have the huge authority and to be able to do emergency actions in times of crisis. And the Supreme Court said that's an unconstitutional delegation of authority and struck it down. So there's some movement in the states, and it'll be interesting to see if that spreads in the states as well, and or in the higher court.
Right. Well, one of the things I always am sort of concerned about is one of the more, let's say, pertinent examples as of late was when Trump was president. He passed famously the right to try legislation, and the right to try legislation basically enabled people who were suffering from cancer or real significant ailments to be able to try experimental drugs FDA had not yet approved. But it had basically no impact because the FDA essentially admitted, and they released a statement basically saying that we don't like this program. They didn't say exactly like that, but that was the clear intent. We don't like this program. We have our own program for experimental drugs. And so pharmaceutical companies don't want to run afoul of the FDA by trying to allow their experimental drugs through this right to try legislation, because they know that on the back end, when they want to, when they need FDA approval for a future drug, the FDA is going to remember that, and they'll be blacklisted in a sense, or be harshly criticized. And so you have the President of the United States doing something, and then because of the FDA, he almost sort of subverts his authority to be able to have legislation impact people, right? And so that's and you can point to numerous examples, obviously, with the NSA, for example, famously lied to Congress about their spying activities. And so all these things sort of concern me from a macro perspective, and in terms of the power the administrative state has. Is there any sort of solution to that other than a president saying that he's going to cut certain staff members or reduce budgets? Is there anything from sort of the judicial perspective? I mean, you mentioned Gorsuch. Can you illuminate that a little bit in terms of things that can be done to counteract this insane levels of authority that these administrative agencies are effectuating.
So I would say the first thing and the most effective thing would be that Congress actually do its job and pass legislation that they read, and pass legislation that takes responsibility and accountability for the policies that they're passing. And there has been, for a generation, if not longer, Congress ducking the responsibility of passing policy and instead saying, we're going to kick this, we're going to create an EPA,
Right.
Environmental Protection Agency, or the National Security Agency, or whatever.
Real quick though, if Congress were to take the lead on these issues, how would they have time to attend the Met Gala and be on live stream on Twitch? They have to balance these things,
Really,
right?
you have to balance. Well, this is what I would say. Article 1, Section 8 of the Constitution lists enumerated powers that Congress is limited to. And if you read that list is really short. And the founders did not expect that list to exponentially grow and to subsume much of what we call the police power that the states have. So the typical police power is health, safety, education, family matters. All those things were supposed to be left to the states. That's what the 10th Amendment says. That's how the design of the Constitution works. And now we have, there's no question that even the most visionary, adamant nationalist, I guess I shouldn't say no question. I don't think there's any question. I might be wrong, but I haven't seen anything from Alexander Hamilton, who I'd put in that camp, or his allies, that say, we can't wait for the federal government to go into all these things that the federal government has now gone into. And so it would really have to be a pairing of Congress saying, we're only going to do the things that are obviously in the Constitution, and we're actually going to do those things. So my position would be that, to return to the kind of the founding vision, you would really need both those things. So that Congress would have to say, we shouldn't be involved in A, B. I'll just say this because it was recommended by then Governor Perry. He said we should get rid of the Department of Education. That's something that has been bantied about for many years. So, education's not in that list. We spend a lot of money on education from the federal level. If we got out of education, then there'd be more time to spend on other matters, which are actually specifically enumerated in the Constitution, Article 1, Section 8. There's been a number of things that have come together that have allowed the federal government to grow. One is they increased the income tax, or they made constitutional the income tax, and that brought in a lot of revenue. The 17th Amendment changed how U.S. senators are elected. They used to be elected by the state legislatures, and that was a check for federal growth. There were lots of problems with it, but there was a check on federal growth. If you knew that the federal government was going to, the Texan senators knew that the federal government wanted to do things that Texas didn't like, they were going to be more responsive, knowing that their job rested on the state legislature versus the people of Texas, who were less concerned about the structure issues and more concerned about the outcomes. So these are progressive reforms, old-fashioned progressives. Right. And so those things, combined with the Supreme Court backing off on the administrative state issues, as well as having a very expansive view of what commerce is. And commerce is one of those areas that it's a enumerated power that they can regulate. Basically, it means any economic activity. So when you combine all those things together, all of a sudden we have a big, big federal government. Right. Founders couldn't envision the income tax, the changing of the meaning of Commerce Clause. It's very clear how that, how originally was interpreted and how it's now interpreted. The 17th Amendment, that's not what they designed. And so it's no no mystery that it's very different than what
Mhm.
we have. So the first thing would be to have the Congress kind of go back to the original understanding of enumerated powers and of the commerce power, and then and take responsibility for what they're supposed to, and do it well. On the judicial side, it would, Supreme Court would have to change its jurisprudence and find that delegation has to be either much more tightly defined,
Mhm.
or just say it's unconstitutional. I think there's more of a likelihood of the first than the second. I don't, just looking at a crystal ball, which I don't have, I'd just be surprised the Supreme Court said you can't delegate authority anymore.
Right.
But they might say you got to do it really well. And a lot of statutes might not survive. And then Congress might say, and this is a real stretch, well, if we can't delegate anymore, if we have to go through the process of making a really good delegation, we might as well just actually pass the law that we think is appropriate as opposed to delegating. So, there's that chance. But that's really up to the Supreme
Right.
Court.
That makes sense. The sort of off of that, one of the big issues, obviously, to this last week has been this essentially vaccine mandate by the Biden administration, and again, cognizant of your ethical responsibilities as a judicial officer when it comes to present matters and cases that may come up. I would like you to sort of analyze it. I'll give my perspective, and then you can sort of analyze the how you think it'll go. So basically, after Biden said that he doesn't believe a vaccine mandate is possible, it's not the role of the federal government, he finagled the vaccine mandate through another way, which is through OSHA, a administrative agency. And OSHA, the way they got OSHA to be able to implement this is for companies with employees over 100 people, is through the rulemaking authorities under a emergency temporary standard. So this allows OSHA to bypass the usual rulemaking process, which entails public hearings and opportunity for notice and comment and all that. And it allows OSHA to basically have something apply immediately. The problem is this ETS, emergency temporary standard, is limited. It requires special justification, and it's limited in situations where to protect employees from, quote, grave danger by, quote, new hazards, or by exposure to substance or agents determined to be toxic or physically harmful. Now, my opinion is that there's no justification under this current situation, because the pandemic has been with us for 2 years. It's not an emergency situation. Doesn't fit under this guideline of being a grave danger of a toxic new hazard. So the OSHA rule doesn't apply. And the fact, the track record for this emergency standard, 6 of the 9 times it's been tried, it's been basically overturned by the court. How do you see this vaccine mandate issue playing out?
So the first thing I would say is we have to go back to first principles. So we have established a constitution that is based on a separation of powers. We do not have a king. We have a president. President's elected by the people through the Electoral College. We have a legislative branch, which is supposed to pass the law. And we have a judicial branch, which is supposed to interpret the law, strike down any unconstitutional acts of either the legislature or the executive, and to make sure that everybody understands what the law means and resolve controversies. So the first question, when the president or OSHA through the president through OSHA makes a rule like this, is does he have a statutory basis or a constitutional basis on his own to do this? So the president's the commander in chief. He's the principal diplomat. He has a variety of other roles, State of the Union, those kinds of things. He does not have, as far as I can tell, nobody's pointed out to me, a authority under health and safety to impose a federal mandate beyond federal employees. There might be a role there for federal employees because he's the executive, he's in charge of federal employees, but not private citizens. So I haven't heard that argument being made. So he doesn't have an independent constitutional authority. So then you have to go to the Congress and say, okay, where is the authority there? So he's using, at least my understanding based on the media, is he's using this OSHA Act. And the OSHA Act then has this rule. So the next question becomes, is the OSHA Act itself constitutional? Actually, usually they look at the statute. First, they'll look at it statutorily. They'll say, is what he's doing permitted under the OSHA Act? So then the question becomes, as you point out, does this emergency rulemaking authorities, does this fit within that? And you would have to look at, has this been reviewed in the past? How have courts interpreted this law? Does this virus COVID issue somehow link into that text? And then if it does, then you get to look at, has the rule been properly promulgated under the act? Because it might not actually, you could have these administrative agencies often pass acts that may actually be unrelated to their delegated authority. So then if the answer was yes, it does fall under OSHA, and they didn't go beyond their delegated authority, then the question becomes, did Congress over-delegate or violate the Constitution by creating OSHA and giving this authority over to OSHA? So it has to survive a lot of different levels of scrutiny. It has to survive whether or not it falls within the rule. Is the rule under the act, and then is the act constitutional? I've heard some legal commentators say it's absolutely constitutional, that under current jurisprudence, Congress has this authority to create OSHA, and under current delegation authority, OSHA can pass this kind of act, and that the act is broad enoughly worded that this mandate falls within it. I've heard other commentators say this is lunacy, that it doesn't fit within the act, or it doesn't fit within the rule, because the rule isn't designed for a disease. It's not an emergency, those kinds of things. And then other people said, and even if it is, it doesn't fall within OSHA, because that's not what OSHA is about. If OSHA is now about diseases, well, that's not what OSHA was designed for.
Right.
So the rule is wrong. And then others would say, and by the way, it's an unconstitutional delegation. So depending on where the votes fall in, you might have a very fractured opinion, or you might have everybody on the same page. John Roberts has tried very hard as our Chief Justice to protect what he views as the institutional integrity of the court. So he likes to have unified decisions. He's very reluctant to have constitutional decisions that change kind of the status quo. At least that's my reading. So it'll be interesting to see if he's able to cobble together, because this has got to go to the Supreme Court eventually. I would think. I'd be surprised if it doesn't. Right. Cobble together a majority opinion that somehow addresses this without threatening the integrity of the court. And it's a real I guess there's two counterweights here that might weigh on that kind of decision. One is that if the court really does perceive it as an emergency, they do not like to override the political branches of government. And the example I would use is Korematsu, where there was internment of Japanese Americans on the West Coast based on a military order that was passed in relation to a congressional act or Franklin Delano Roosevelt's order. I can't remember which at the time. Might have been both. And the court said bravely 60 years later, then Japanese internment violated the Equal Protection Clause. They waited 60 years to reverse that case. Okay. So there could be, and I don't mean to be disrespectful to my brethren, but there are times when there's a crisis and the judiciary just does not want to wade into it. They want it to be settled by the political branches. And so they find every way they can to not have to make a decision that overthrows what the political branches have done. On the other side of that is that if that is constitutional, if one president with a stroke of a pen can declare an emergency and mandate for tens of millions, if not, I don't know, it's 80 million, whatever it is, tens of millions of people that they must do this, then some would say there was no limit anymore to the Constitution, that we have blown up the constitutional limitations around presidential power and congressional power and enumerated powers. That's all gone, because they'll always be able to find some creative way to have an emergency rule that will override the clear and obvious restrictions of the federal government. And if you look at enumerated powers, there isn't a health and safety power. So they're trying to do this through interstate commerce. The Supreme Court, in the first Obamacare case, I think it was the first one, ruled that you could not compel commerce, because Obama was saying, the Obama administration was saying, you have to buy, there's the individual mandate, you have to buy health insurance because it affects the health insurance market. And the Supreme Court said, no, you cannot compel people to engage in commerce. There was an act many years ago that was the Violence Against Women Act. And there was some kind of perfunctory congressional findings that how violence against women affected interstate commerce. And the Supreme Court said, no, you can't ban violence against women through the Commerce Clause. That's not commerce, that's criminal behavior. So you could see this case going either way for a variety of different reasons. It will be one of the most fascinating cases that we'll have in this generation, but it strikes so fundamentally at the authority of the court and the limits of the Constitution, that if that action is affirmed, then we're talking a whole new ballgame with regard to the federal government's ability, because it's a regulation. It's not spending. It's not saying we're going to spend, we're going to buy 80 million masks and give it to people for free. It's it's not like the vaccine, which I've had. I got no problem getting it. I was pleased to have it. Spending money to distribute. It's not that. It's ordering people to do something, and that usually is there's a significant increase in authority if that is affirmed, especially when you're talking about, I suppose you don't have to get, you can be tested, but a test is an intrusive procedure. Obviously getting vaccinated is an intrusive procedure. So it's not just, don't do something, it's do something. It's another step. It's not like saying you're banned from blowing up a building as a terrorist. It's, you must either get a test, you have to do something. It's compelling you to do something, which, there's also an argument, I just thought of it, 13th Amendment, no involuntary servitude. Someone could say, you're forcing me to do something, you're not paying me to do it. Why isn't this involuntary servitude? So it raises all kinds of fascinating issues.
Right, absolutely. And like I said, it'll lead to a precedent for all sorts of future actions by federal government, which will go way beyond what we thought was within constitutional limits. You could see a situation where they justify something under climate change, that this is a emergency situation because climate change is here and it's causing a temperature rise globally. So therefore this action is justified under that. So absolutely causes a very dangerous precedent. With respect, I want to ask you a couple more things. So another sort of hot button issue is the Texas abortion law. It came before the Supreme Court. So the background of it was Texas passing a abortion law that basically prohibited abortions once you could detect cardiac activity from the fetus, basically around 6 weeks. And the interesting way that it's enforced is basically, instead of being enforced from state officials, it allows any person to sue any person who performs post-heartbeat abortions or who aids or abets them. And prevailing plaintiffs are promised at least $10,000 of statutory damages per abortion. So this was sort of designed to prevent certain challenges against the law. When the Supreme Court basically declined to strike it down, and they stressed basically looks like they declined on procedural grounds. Could you sort of elucidate the situation for us with respect to what the Supreme Court said and where this case is likely to go?
Yeah, so what happened was the Supreme Court, as you said, declined. They didn't decide to not strike down the law.
Right.
They decided not to take the case to stop it from coming into effect. And that's different than a finding on the merits. And in fact, the order says we do not make a ruling on the merits. This is unusual in the sense that many restrictions against abortion are often stopped by a court before they take effect. And the Supreme Court often weighs in on that, saying that decision is appropriate, and holds the act from stopping to become effective until there's a litigation about the case and whether or not the abortion restriction is constitutional. Now, we have in the country a jurisprudence which is somewhat murky about the right to an abortion, but basically there's a recognized right to have an abortion, and that no state can impose, or a federal government can impose, what's called an undue burden on that right. What an undue burden is has been murky.
Right.
And so, some things are not undue burdens and other things are. This Texas law is very unusual because it's very clever. I'm not sure for the good or for the ill, but it's very clever because it's not enforced by governmental authorities. It's enforced by civil litigants. So, and apparently anybody, I'm not sure if it's just people from Texas or anybody, can say, can sue to stop someone from obtaining an abortion, or at least they can sue the providers the medical providers that would perform the abortion. And so, and if they do successfully stop somebody, they get a $10,000, the people that oppose it call it a bounty, and they say they're bounty hunters. I'm not sure what's the phraseology in the legislation, but they get $10,000. So an incentive to do this. Normally, when up until this point, when an anti-abortion law has been passed, or a pro-life law has been passed, it's enforced by the government. And so you know who to sue, and you can get an injunction against it from coming into effect. Here, you don't. Who do you sue? You sue everybody in the state of Texas.
Right.
So there's this enforcement issue. Now, on the other side of it, someone could say, well, I'm going to ban handguns in the state of Texas, And we're not going to let the government enforce that. We're going to let private people enforce that. So you can sue somebody that has a gun, a handgun, and you get $10,000. So you always got to look at it both ways. Do you really, is this clever mechanism something you really want to have in the law forever? Because maybe Texas is going to pass that law, but New York City might. They already tried to do something very similar to that. So whether or not the courts just put that aside, or that's a new area of litigation, it's going to be very complicated. But they haven't made a decision on the merits. And the way that I see this happening, one way, there's others, is that somebody finally sues one of the operators or an individual that wants an abortion, and then there's an emergency hearing, and then there will be some kind of decision that comes out about whether or not the heartbeat law is an undue burden or not.
Right. Going back to the Casey decision, right?
Right.
Yeah. Yeah. Have you seen this? This is a very interesting mechanism. Have you seen this play out before? This sort of enforcement?
I have not. I mean, there are areas. There's one area in Michigan that's a little funky, where there's a termination of parental rights. So if somebody is neglectful or abusing their child, the state can come in and terminate the rights. But private people can also do that, which when I only did family law for 1 year, but I was always surprised. It didn't happen a lot, but I'd get a case where some interested person, wants to terminate the rights of an individual. And so I've seen it there. You could also, civil commitment of mentally ill people is usually brought not by the state, but by a relative, where they say, my father or my brother or whatever is going to hurt himself, and they go to court and they petition the court for that commitment. So those things do happen in other areas. Whether or not that changes the constitutional analysis, I don't know. I haven't given. Thought yet.
As I said that, I was just reminded of in California, you can a private citizen can sue employers for things like wage violations and things of that nature on behalf of the state and enforce it. So that's somewhat of a corollary. The last question I have for you is regarding the issue with big tech, Facebook, Google, etc. This is obviously this is currently and will be one of the most hot button issues for next several years, and we don't know exactly how it's going to play out. There are two components to it. It's actually bipartisan in drawing ire from both sides, institutions like Facebook and Google. There's an antitrust aspect, which finds that entities like Google are basically using their market power to hurt consumers by destroying other competitors. There is, and also Facebook as well. There is issues from the right wing, which basically deem that these institutions are playing the role as almost quasi state, quasi government actors. They're obviously, Democratic politicians, for example, have told Facebook and Google and Twitter what to do under testimony and have threatened them. And then they've gone and done certain things in terms of prohibiting certain people from the platform. So you can find state action there. There's also the concept of them, being the marketplace, being the sort of central town square, for example. There are people who think that they can be regulated as utilities, and maybe that's the answer to sort of stop their ability to discriminate against people if they're regulated more like public utilities, and that entails prohibitions on being able to discriminate against certain people and how they can operate and things of that nature. How do you sort of see the merits of the arguments against big tech from both maybe a antitrust corporate perspective, and also from a, them acting as a quasi government, and therefore, they have to abide by the First Amendment. How do you make sense of all this?
I'll tell you, this is one of the most fascinating issues that we have come across, and what we, the law is usually a laggard. The technology, as is morality and ethics. So the technology often outstrips the ability of the law or ethics and moralists to get theologians as well to get a hold of what's going on. So here is one of those circumstances. One easy way to look at this is that despite all of its market power and despite its dominance at this moment, the bottom line is social media is still private owned. And that they should have the ability, like any other privately owned institution, to determine the content of what happens on their platforms, and that there's these user agreements that people are expected to follow. And if Facebook doesn't want to post pro-Trump stuff, that's their constitutional right. In fact, it would be unconstitutional to force them to have to foster speech they don't like. It would be like me saying to you, Ashton Cohen, you have to host, now that you've had Judge Warren, now you have to have a jurist who is very, very progressive on and explain their position. We used to have that with the FCC. We used to have a rule on TV that you have to carry certain content, and you had to have a balanced view, because the airwaves were a public utility, because there was finite. The FCC would issue you a channel or a license to broadcast, but because it was really the public airways, you had the responsibility to carry both sides. They got rid of that several years ago, and because of cable TV and other developments. And now that's why you have Fox News versus MSNBC, right? Because they don't have to follow the fairness doctrine, that's what that was called, or other requirements. In the cyber world, they would say there's this unlimited bandwidth that you could have. There are other opportunities for conservatives or communists or fascists, whatever it is, to create their own platform, and you shouldn't force them to, just because one's particularly big and they're successful doesn't mean that you require them to have to carry content they don't agree with. Of course, the reality was there was Parler for like a nanosecond, because everybody said, "Oh, create your own network if you want to." They did, and they shut it down. They being, the service entities. So you see that and you go, okay, well, maybe these folks are the new public square. And the public square means that you can't have what's called content-based restrictions. Mm-hmm. So if you go on a park that's a public park, you can have what's called time, place, and manner restrictions, and you can't give speeches at midnight with big, huge, blaring speakers, but you can go there, between noon and 8. And if you're going to let anybody speak there, then anybody can speak there. You can't deprive them based on their content. So you can't say, well, we only want Republicans to speak here, or libertarians or Green Party people. You can't restrict if you allow anybody to speak. So there's been some, that's going to be the real question is, are the platforms like Facebook and Twitter, mm-hmm. And others, are they so big and so dominant that they in essence are becoming the new public square?
Right.
Or are they more like the mall? Because mm-hmm. there was some mall back in the 70s. Some people don't even remember the rumor malls. Back before Amazon and all that stuff, you'd go, and Michigan is the birthplace really of the modern mall movement, the closed in structure, because it's so cold in the winter. That you'd go into the mall, and that's where most people went to shop. And so people would start handing out literature, And there were lawsuits over that. And at one point, there was a ruling that said, well, they're the new public square. So the mall owners lost control over what could be distributed. That was reversed. And it was determined, now and forevermore, at least as of now, that mall owners don't lose their ability to control the content. And so they can kick people out if they're just the Hare Krishnas or something like that, trying to evangelize. And so, and airports, which is a public entity, most of them, but they even said they can have these restrictions. So unless there's a real change in jurisprudence, and there could very well be, but unless that gets changed, I think it would be hard for a court to rule that they've morphed into a public utility. So public utility is, your water, your electrical, whatever.
Essential services. Yeah.
Just because you're a Nazi doesn't mean you don't get electricity, right? Everybody gets their utilities. And so the theory is, well, social media is the new utility. And it's so essential to modern life that it's just like electricity or water service. And I'll tell you, for the kids that I talked to this morning, the 8th graders, there's no question they view it that way, right? This stuff is like part of their identities and their lives. It's central to that. For other people like my parents, they don't even have Facebook, so it's not essential. So it's a really interesting issue that the court will have to grapple with. It
is interesting. So one way to look at it is Facebook, which has 1/3 of all humans on Earth on its platform, right? So it's something like over 2 billion accounts. And then you add an Instagram as well, which it also owns. Is that more like a modern town square, or is that more like a mall? And I think if you look at it that way, it seems to be more the former. And as far as it's being essential, these it would be interesting. I think so. Kennedy in when he was in the Supreme Court mentioned this in his dicta, basically saying that, these are private entities, but they're not like your typical private entities. Thomas has hinted at this as well in Supreme Court decisions. And I'm immediately reminded of, I think it was Marsh versus Alabama, where it was like a company town back when company towns were kind of a thing. And the Jehovah's Witnesses were putting up, their religious literature on the town bulletin board. And I forgot the entity in question, the company was like, well, no, you can't do that. And the Supreme Court said, no, actually, you guys are kind of acting like you're as a state actor, you're quasi government actor in this situation, and so you can't prohibit them. You're bound by the First Amendment as well. I think that I haven't seen that argument made as much. I don't know if you have thoughts on that, but I think that kind of approach seems to make sense to me as a corollary.
Well, that is a very interesting case, and in some cases are what we call sui generis, which is unto itself, it's unique and might not really have application to others. And some people like to talk about any case involving the Amish, right? Because they're so sympathetic, and they're trying to protect the lifestyle of the Amish, and so they get like these special exemptions which would never apply to anybody else, but they're the Amish.
Right.
One could argue that the company town is like that it's so rare, and that it's really so unique that it isn't good precedent for other places. And so if you live in a town that's owned by a company, everything is owned by the company, the homes, the stores, the roads, the whatever, then it in essence has become the government. And therefore this kind of ruling applies. So I think, the argument is there, and it could be made that, but it would almost be as if, I think it would be a much stronger argument if you had one entity that controlled all of the internet. and that, I mean, it probably existed in the past, right? You have one entity.
It's arguably Google, I mean, if you really think about them being like the gateway to the internet for.
Yeah, but you have DuckDuckGo. I use DuckDuckGo. I don't use,
So is that like a 3% market share though?
You got it. So, but there's nothing stopping you from doing that. So if the internet was owned by one entity and there was only one social media platform, much stronger argument for the company town than a lot of different platforms with the government really used to created the internet. I think now it's in a whole bunch of different people's hands. So I'm not saying it's a credible argument, but I don't know that it would carry the day in the end.
Yeah, I think there are a couple more. There are a couple. That was just sort of what I was reminded of. I think there are probably a couple more compelling areas that you could draw a link to, including examples of Democratic legislatures, telling Facebook and Google, this is what you got to do, and then they do it, and then holding to the standard. Well, a government telling a private corporation to do something that the government can otherwise do, maybe an example, state action. I'm still sort of looking, I'm still sort of educating myself on the different ways, because it is complex and it's unique, and it's very interesting.
Yes, absolutely.
Yeah,
absolutely. Right. So it will be, I don't think the Supreme Court has anywhere near resolved. I don't think we can read any tea leaves, I guess, on this and make a decision about how this is all going to turn out. I think that's true.
Yeah, that's true. Right. Well, Michael, thanks so much for being on. It was a real pleasure to have you on. I think you really illuminated so many concepts that you don't really hear about on the news. You only hear about snippets. Texas just passed this law and it's unconstitutional. You don't really get in depth in terms of why did the Supreme Court do this? What's the real situation? What's the real jurisprudence underlying this? What are the concepts underlying it? Which is why I think these sort of podcasts are so helpful. So I really appreciate you coming on. Where can people find you?
So a few places. The book is, again, America's Survival Guide, How to Stop America's Impending Suicide by Reclaiming Our First Principles in History. And you can find that at americasurvivalguide.com. Or at Amazon or any other online retailer. If you happen to be in Michigan, I'll sign it for you in person. But again, that's americasurvivalguide.com. Patriotweek.org is an initiative that goes from 9/11 to 9/17. So we're recording this on 9/17, which is Constitution Day, where we celebrate our founding first principles, key documents and speeches, founding fathers and other great patriots, and flags from our history. It's all about civics and American history. With a lot of law interlaced there. So your viewers and listeners might be interested in that. And that's patriotweek.org. You can also reach out to me directly at M as in Michael Warren, WARREN, at patriotweek.org. I do have a Facebook page. So Michael Warren on Facebook, is LinkedIn, Michael Warren on LinkedIn, as well as Twitter, which I don't use as much because you can't have these kind of conversations on Twitter. But you can certainly reach out to me there.
Right. And I'll put those in the show notes. So excellent. Well, thanks so much for being on.
You're welcome. My pleasure. God bless you and God bless America.
You too. Thanks. If you enjoyed our show, please click subscribe to stay up to date with our YouTube channel and podcast, and give us a 5-star rating on Apple Podcasts so that we can keep delivering guys some great content. Thanks for listening, and we will be back next week. We're going to talk about the issues that really matter. Our country, our economy, the Fed, QE, GDP, BTC, NFTs, AOC, the CCP, Cardi B, Yeezy, Yellow Socks, Iran, Joe Biden's dementia, come on, man, and probably sex robots. We stand for a free and open debate and exchange of ideas. And if you disagree with anything we talk about, you are a racist and no better than Hitler. What? Let's get started.